Mark, if you want to go ahead and get started whenever you'd like.
Thanks, Lindsay. Welcome, everyone. My name is Mark Leckington. I'm honored to be the Vice President of Affordable Housing Professionals in New Jersey, and I'm equally honored to be your host and a panelist today on our call. We have a pretty large expected attendance. We had over 150 registered to join. There's already 103 of us here today. This is I believe this is a record for the organization, which has been around almost 20 years. So it's very telling that this is a timely topic and with a lot of interest. Um, I spent a lot of time thinking about this sort of introduction today before we get into the agenda, and I would be remiss if we didn't take a moment and recognize the impacts being felt across the affordable housing and community development landscape right now. Everyone has probably heard the theory that many people don't realize they are directly benefiting from federally subsidized programs. The person receiving a free refurbished laptop from Computers for People probably doesn't realize it was partially funded by the Hoboken CDBG program. The Princeton Housing Authority resident visiting the optometrist or dentist today for the first time in many years may not know to credit the HUD project run by the Princeton Department of Health. The latest partner family buying their first home from Habitat for Humanity of Gloucester County might not realize that it couldn't have been possible without the county home program. I want us all to take a moment and apply this same theory to our own perspectives in the affordable housing space. Within our local and regional affordable housing systems, we're likely depending on nonprofits that would fail to exist if it weren't for their access to federal funding. A group that's even further under the radar are individuals within these nonprofits and various levels of government that are fully federally funded. Those administering and planning our state, county, and local CDBG home, COC, and other programs are directly impacting the housing we are creating and the services our tenants and buyers rely on for their success. My purpose in bringing this up today is, one, to personally recognize these situations these organizations are in right now, and to two, encourage you all to take stock in your communities and networks for the presence of organizations and individuals that are vulnerable right now. If you want to learn more on what's going on at the national level, I highly suggest visiting the National Low Income Housing Coalition website. It's a great place to start to learn about the impacts and some strategies for mobilizing your networks. With that, let's get started. First off, a recording of today's session will be made available as well as the slides. So if you're already find yourself typing that question in the Q&A, you can stop. We are gonna share them all. And I also want to try to channel our esteemed president, Ed Schmier, for a moment and remind you all that the content you are receiving today should not be considered legal advice. Prior to acting on any of the rule changes and any of the discussion today, we suggest that you consult with your professionals. You'll probably hear this once or twice more today from our panelists. Our goal today is to help you all understand the major areas where changes have been made and to encourage your participation in the upcoming public participation process that will allow you to comment and provide information and feedback. That process will likely start shortly, and we'll talk a lot more about that soon. As you'll see, the changes are significant and very detailed. Some individual rule changes could consume an entire webinar on their own, and many likely will in the coming weeks and months. Before we get to our first slide, I want to take a moment and recognize several people that were instrumental to bringing this session to you all today. The groundwork for this session started shortly after the rules were released in December. A small group of administrative agents and professionals, including myself, Megan York, who's a panelist today of CGPNH, Frank Piazza, also a panelist today of Piazza and Associates, Mary Beth Lonergan of Clark Caton and Hintz, who I know is in the chat, and Heather Mahaley, now of the Department of Community Affairs. We began meeting over the course of about 10 days to do a complete line-by-line review. In total, the group met for more than 20 hours, and I just wanted to thank you all and recognize the importance of finding that time to meet during an extremely busy month where perhaps maybe the busiest 30 days of the last 10 years in the affordable housing space. So I just want to mention, I just wanted to say thank you. Those contributions to the profession and the legacy of our affordable housing will pay dividends for a very long time. So thank you all. All right, I'm going to share my screen now, and we'll go over a little bit of an agenda and some ground rules for our call today. All right, so on the left-hand side, we've got some topics that we're going to be talking about today. On the right, there's some contact information for everyone. Other than a slight reshuffling of the order, there's not much new from the initial information that was pushed out on this session. So the topics that we're planning to talk about are still are relevant, just maybe reshuffled a little bit for convenience. There's also this, this is going to come up multiple times during the course of the conversation today. We've labored over this text, and I got to thank Megan for taking the time to jot it down and turn it into a slide here. We're really, again, our goal here is to highlight the changes that have been made to UHAC, and some of the questions that we have about some of the changes as well. It's there. You'll see that while we're happy to talk about what is actually in the text, there are some clarification needed in some cases, and to make these rules effective and predictable and fair. So we're still, it's a work in progress, if you will. Our recommendation as a group and as AHPNJ is that we caution you and ask you to consider holding off on making any changes now. As we'll talk about in a moment, the rules that we are discussing today are temporary, and they could be further revised within the next few months. We are happy to report that HMFA and DCA have been incredibly active with not only the edits that were made in December, but in working on calculators and other supporting materials that will be made available after the final rules are approved. And we'll talk a little bit more about that in a second. We're expecting that some of these rules that we're going to be discussing today are going to be revised in a final version of UHAC. So we've got a situation where things may change even further from where we are in what we're discussing today. And of course, again, channeling Edgemere, check with your attorney. There's about the best course of action in integrating these rules at the local level. The last thing we're going to mention, and this will come up several times today, is that there is a review and comment period on the final version of these rules, and we are asking you at all to consider participating in that and helping refine and improve the processes and procedures and regulations that we're all working under. And with that, I want to go do a little summary of UHAC history. I know there's at least a bunch of us that were around when the original version of UHAC was adopted in December of 2024. I'm sorry, the original version was dated 2004, and they were within the regulation. It had a sunset clause, or an expiration, if you will, of the rules, and that sunset clause was December 20th of this past year. And then in the spring of last year, almost a year ago, I think it's a year ago in 2 weeks, about 50 weeks ago, S50A4, otherwise known as the Fair Housing Act, was signed into law. This substantially revised a lot of the fair housing process, and included in that was a requirement that UHAC be updated. And as silly as this sounds, here we are many years later, after the New Jersey Council on Affordable Housing was determined by the state Supreme Court to be moribund and ineffective. These S50A4 removed COA from the regulations permanently. The importance of that was that New Jersey COA, in the prior regulations, COA was a party to all changes to UHAC. So if the idea that it was not a body that was meeting basically stymied the ability to make changes to UHAC until those rules were changed. So you can now see that A4 set the stage for the changes that we're talking about today, and allowed that to sort of to begin. Almost immediately after A4 was adopted, HMFA began reaching out to convene roundtable discussions, soliciting comments and suggestions. What I'm really I'd also like to highlight is that when they initially reached out, as the AHPNJ immediately sent off a memo that has been worked on and improved and refined by the policy committee that listed a large number of changes to the rules, some really nuanced little things, some closing of loopholes, some updating of processes with technology. And I am very pleased to tell you that almost every one of the rule changes in the December edition of UHAC can be traced back to the suggestions and information that was provided by AHPNJ. So while it was a very long 20 years of living under the prior rules, I'm happy to tell you all that the policy committee did finally get a lot of the rule changes that were asked from the policy committee did make it into this set of rules. So now, this is incredibly important. This is very confusing. In fact, we only got our arms around these next few steps within the last couple of weeks. So let's talk about what happened on December 19th. As I said in the first bullet, on December 20th, the rules were due to expire. On December 19th, an emergency UHAC regulation was signed by the governor, and under that emergency rulemaking provision, there was no public comment period, there was no back and forth, there was no public hearings or any feedback. That's not to say that that HMFA was not working with stakeholders and conducting numerous roundtables and sharing drafts of text, and there was a very rich and exhaustive almost process of participating in this process. So it's not as if these were, I don't want to give the impression that these were completely written in isolation. There was a lot of feedback and a lot of opportunity to educate the process. However, that process did not meet the test of a full-blown regulation process as prescribed by the state, where rules are published in the state register, people are allowed to comment on those rules, feedback is provided by the rule maker, and it evolves over maybe one or multiple versions of publishing the rules and soliciting feedback. It just did not meet the test of that. So what the emergency rule provision require is that that emergency rule can only last 12 months, and that in order to finalize the rule, a new set or a finalized version of said rules has to be made available, and that public participation process has to happen. You know, it's publication in the state register, comment process, all those sorts of things. So despite the fact that the governor signed all of the rules that we are going to be talking about today, and they are technically the law of the land as we sit here, there is going to be an opportunity to comment on them, and there may still be either further refinement on these rules as we're even discussing them today. So, and I'm also very happy to say HMFA, within just a couple of days of the governor signing the draft in December, HMFA was hard at work on convening additional roundtables and additional feedback to finalize the rules. And the last thing I want to mention on this slide is you want to be very careful about trying to Google UHAC right now, because the original 2004 version still exists on a lot of state websites and a lot of places around the internet. You want to make sure that you're looking at the 2024 version of UHAC. And it does not have the fancy cover on it that you all may remember. It's just text. And I want to take you very quickly just give you a couple of quick tips on navigating the draft of those regulations. So Here, I took a little screenshot of a section, and this is, as you could probably guess, this is from the definition section, right, where they define various important terms. And I just wanted to show you that there's some things going on here that are worth, and they do describe this in the recitals, if you will, or the beginning of the document. But it's worth sharing with you very quickly, just because we've learned a couple of tips and tricks as we've been going over this. So this is all the bolded text is new, right? So that all these two things that I've highlighted are new text and part of the new rule. Then we have these bracketed things that are all being removed. It is very important to note that there are some sections within this document where the deletion spans an entire page, meaning that you could find yourself, if you say you're word searching a topic, you could find yourself in the middle of a page looking at some text and expecting that text to be applicable at the the sort of prevailing text of on that topic. However, there could be a bracket up on the prior page and the closing bracket on the next page. So you be very careful and keep an eye out for that. It's might be a good exercise to search for brackets and maybe highlight the text in between them. That's certainly worth doing. And the last thing I want to point out is that there's not too many of them, but it's worth calling out. There's these dots throughout the text that represent a group of text or several entries that remain unchanged. These are the dot 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 basically means there's things between division and high poverty census tract that are not being proposed for change, and there's no new additions in there either. So definitely worth noting that as well. All right, with that, I am going to turn it over to Megan, and she's going to take us through our first couple sections.
All right. Thank you, Mark. That is a great introduction, and sticking, I guess, kind of with the ground rules theme that Mark was just talking about. The first part of the new regulations does talk about applicability of UHAC, very similar to the previous version. And what it says is that the rules are applicable to units receiving credit under the Fair Housing Act. Credit is the units are in a court-approved settlement agreement, judgment of compliance, builder's remedy litigation, or there is a COA credit. Also, the rules, this is like a page 1 thing, says that these apply to units receiving state funding, whether it's through DCA and programs such as the Affordable Housing Trust Fund, or HMFA through programs like the Choice programs. However, there's also exceptions. So and this is also in the previous version of UHAC, there were exceptions too. The first one I've highlighted here is related to federal programs. It is called out in UHAC that federal programs listed here, tax credit, balanced housing under HMFA, Home Express Loan, HUD 202, HUD 811, etc. These rules do not apply to them. However, there is a change in these rules that does specifically call out newly constructed low-income housing tax credit units that receive credit under the Fair Housing Act must be affirmatively marketed in accordance with UHAC. I think the biggest thing there that is different for tax credit projects may be the random selection process that is called out in UHAC. So this is a change that we are seeing in the new regulations. The other applicability area that is worth mentioning is related to inclusionary units. I think it's clear that these rules will apply to all units that receive credit in round 4. There is some specific call outs for earlier units. I'm going to call them round 3 or earlier, or created earlier. These are units that receive substantive certification before the rules came out in December of last year. They were part of a judgment of compliance, or they are subject to a grant agreement. There are a couple areas where it specifically calls out that aspects of the rules do not apply. That includes some of the building standards sections that Frank is going to be speaking about physical characteristics of the units, And then also the 40-year control period that I'm going to talk about in a few minutes for rental units applies to round 4 units, but does not apply to these units that were created before these rules came out. We do have, and it's gonna be a theme throughout some of the presentation, is the applicability of all the rules to all units that have received credits. And I'm going to let the other, namely Frank, talk about that with some of the policies related to administering units and how that will be applied for the older round 3 and older units. So that is the applicability of the new rules. I'm going to jump right into, some of the actual topics. This is we're getting into the weeds here, and as Mark mentioned, these topics could really be presentations, hour and a half long presentations on their own, and we are still trying to really get a handle on what the new rules are and what the ramifications are. I'm going to try to highlight some of the changes and some of our initial thoughts on what we're seeing. Affirmative marketing, the headline here is really, there's a lot more choice in the affirmative marketing that's required and allowed, and that digital options are really taking front and center in the affirmative marketing for affordable housing. This reflects the changes that have happened in the last 20 years with internet and how people are searching for housing. There are certain things that are required. Units must be posted on the state's New Jersey Housing Resource Center housing search website. They must be posted for at least 60 days before random selection process. There needs to be one advertisement in a regional paper. The units must be posted on one housing search website, and the applications must be available at various locations: the municipality, library, municipal website, county admin buildings, and the location in the settlement agreements. Then we have some options. For starters, we have to pick one additional digital strategy. That can be another housing search website, social media sites, or digital paid ads, such as an ad on NJ.com or one of the tap into sites. And then thirdly, you need to pick one additional non-digital strategy, which could be an advertisement in a neighborhood-oriented paper or religious publication, mailing to community groups, major employers. And there's one specific strategy that is called out in the regulations as an option, is posting of the option at public transit stops in the region. So definitely changes to the affirmative marketing based on changes with the digital options that are available now. And there is also one note in the regulations that says if you can demonstrate that you have a better way to meet the target population, that local planning services may approve a plan that substitutes some of these requirements. I did want to speak just a second about the housing search website, because when I first saw this, I thought it was pretty interesting. I think a lot of people are looking for housing on places like apartments.com. So I wanted to sort of see how would that work for marketing something in a 60-day window that's going to have a waiting list to try to get the word out to people who may not be aware of this housing opportunity. This is from apartments.com site, and we're struggling a little bit with it because the way these sites are set up is that all they seem to be geared towards creating leads for realtors, essentially. So we cannot link to a website on how to apply, and everything comes through as an email lead, or the phone number is run through apartments.com and then comes to us with someone saying, I'd like to get one of these units. I think that this is creating, it may not be the best fit for affordable housing that has a 60-day marketing period and wait lists that, run into the thousands, to have, such a emphasis on handling leads at this point, when really the purpose is to get on a waiting list. So the housing search website initial thoughts are perhaps focusing on housing search websites that are affordable housing oriented rather than some of these market sites that are common in the marketplace right now. Just some other general thoughts about the affirmative marketing. The New Jersey Housing Resource Center, which I've mentioned a couple times, still remains, really the pillar, the starting point of all the marketing. The posts have to be up for 60 days, and you must accept applications for 45 days. And there's a provision for only 30 days if it's a resale unit. The rules clarify that you cannot conduct a lottery during this window while you're accepting applications in that 45-day period. Your other advertising must take place during the first week of the marketing. And the rules also call out that housing that's geared towards special needs population and housing for the homeless, you must notify the local continuum of care for these populations. And there's also mention of the New Jersey Fair Chance and Housing Act, which was passed in 2021 and has to do with background check law that it's very important to follow this law. It does apply to affordable and market rate units. I'm going where we have a lot to cover, so I'm going to just keep on trucking here and go into some of the control periods for rental and sale units. I've already mentioned that newly created units that'll be part of the round 4 will have 40-year controls. This will not apply to units that before December 20th, 24 received substantive certification, was part of a judgment of compliance, or was subject to a grant agreement. So a round 3 project that has not been completed yet will still have 30-year controls. The rules also have some information about, I interpret this as no matter what the deed actually says for your rental units, UHAC regulations apply. For example, we expect that there will be form documents that are available. If they're edited in any way, language added, that there's a UHAC says doesn't matter, the UHAC regulations apply. The rules in the rental section also have a new emphasis on getting deed restrictions recorded in a timely manner after the certificate of occupancy. The control period for rental units will start at the certificate of occupancy date. Previously, it was the date that the first tenant occupied the unit. So this is a change that we're seeing. And we are expecting that there are form documents in the rules that were put out in PDF form. We're expecting those to have some revisions in the new version, and also eventually, we'll have Word versions that we can work with to have, when we actually are preparing deed restrictions for projects in the future. At the end of the control period, there is if the controls for rental units are not extended, there's really not much of a change. If the controls are not extended, the controls remain in effect until either the occupant vacates the unit, or the household income is certified to be greater than 80% of AMI. I do want to emphasize this because we are seeing rental units that are either at the end of the control period or very close to being at the end of the control period. If a municipality is choosing not to extend the units, or if they're not being extended, it's important for everyone, the administrative agent, the landlord, to understand that the units do not become market the day after the end of the control period. The current tenant either needs to move out on their own wish, or the tenant household is certified to be over the moderate income limit of 80% of AMI. The rules, this is where things start to get major changes here. There are provisions for how a municipality extends rental controls. Restricted units will be released unless the municipality exercises the first right of refusal to extend. To do that, they must, number one, pass a municipal ordinance extending the units no later than 180 days prior to the end of the control period. So that's a pretty big, you need to be cognizant of when the controls are expiring and make sure you do pass this ordinance in plenty of time. 2, the municipality needs to issue a new deed restriction extending the controls. The minimum control period for combined credits of 1 and 2 needs to be 60 years. So if the units were originally 20, that would be a 40-year control. So 60 years need to be the total period. If permitted, grant a pilot. And then the rules also say that there needs to be some sort of per unit financial contribution to support the extension of controls. The figures that are in the regulations from December are $12,000 per unit with a pilot, $17,500 if they don't have a pilot. And then it says, or other assistance not less than $10,000 per unit with approval from DCA. So that's what, it's looking like at, with the December rules for extending the rental controls.
Megan, for the folks that are
yeah.
on the call today that aren't familiar with pilots, could you just expand on that slightly?
Yeah, that would be projects that are getting a payment in lieu of taxes that municipalities can grant. It's typical for particularly 100% affordable projects to have pilot, and some of the inclusionary projects may or may not have a pilot associated with them. So that they generally support the production of affordable housing. My last slide is related to sales units and the deeds and extension of controls there. The rules also say that for controls to be extended on units that are sale units owned by affordable households, that they must give 180 days notice before the end of the control period. Like rentals, the total period must be 60 years or greater. So if the initial control period was 20 years, then the controls would need to be extended for 40, bringing it to a total of at least 60 years. And the owners must be compensated not less than $20,000 to extend. I'm not going to get too into the sales process here, as HMFA has indicated that they're going to be making additional changes to the sales deed restrictions, and possibly this whole section seems to be an area of their emphasis. We are expecting that like the rental deed restrictions, we will get new form documents that we will use, when we process homes for sale. And with that, I am going to turn it over to Frank.
And I'm going to turn the slides over to Lindsay. If you could put the slide up, please.
Oops. Hold on 1 second.
It's okay. While Lindsay's doing that, I'm Frank Piazza. We've been working on this for as Mark mentioned, and easily 20 years trying to get some tweaks to the UHAC regulations, and thank you to the people down at HMFA who have been coming up with very creative ways of helping us see the changes through. So I've been pretty impressed by some of it. But it does make for a little bit more confusing or convoluted regulation. Again, I'd just like to go through a few things: building standards, bedroom income distribution, and program equity fees and amenities. And not going to get too deep into any one thing, and I'm really just going to highlight the changes, the modifications in the rules from what we currently have. The first noticeable thing is that there are building standards now that are more detailed, and they are broken into 3 categories. Those projects which are 100% affordable, the projects that are 100% affordable rental units, 100%, and I'm sorry, the second bucket are the projects that are inclusionary developments with a portion of market and a portion of affordable rental, and then a bucket for the sale and sale rental combination. So the first bucket is with 100% rental property. I think, most often that's going to be a tax credit property, or a municipally sponsored property. And basically, there's not a lot written down for changes. There is a minimum square footage. It has to be the higher of the local code or the neighborhood balanced housing program rules. For the first time, we're going to see a window required in every bedroom in every affordable housing unit, not only the 100%, but all the buckets. And then adequate AC and heating is another requirement. And again, with 100% projects, a lot of times the funding is going to determine more specifics. If you could go to the next slide. So these are the inclusionary rental units. And in inclusionary rental units, you have 80-20, whatever the combination of units. Now we have market units that will be used in the rules to be the standard for the affordable units. And so the one thing is that they have to have the same building standards, and I think they're really talking about the construction standards, et cetera, absent the requirement that there be interior finishes that are comparable. Everything else has to be comparable. The square footage has to be equal to or greater than what the most common market unit is in terms of square footage. So there's a lot of equity there. They need to be dispersed among buildings and then within a building evenly dispersed. And I think that the new rules are really trying to make that clear. There's kind of 2 options for dispersal within each building, and then the number of buildings that include affordable units. I don't know, this seems to be a little bit more subjective. Not all of the affordable units can be placed in less than desirable locations. I don't know, that might be desirable for one and not the other, but that's kind of where the rules are at with that. I think there's an exception for penthouse units that can be reserved for market tenants. Access to all of the community amenities, that is not only for these rentals, but you'll see them also for the sale units. So that's something that needs to be communicated. Well, when we get to that, it needs to be communicated to the associations, et cetera, for long term. Adequate AC and heating, again, a bedroom window. And now we're looking at the same building type. And for the rentals, I think they're making it clear, at least at this stage, that if you have a townhome to rent, and by townhome I mean an upstairs, downstairs with an interior staircase, if you have those types of units to rent, then you would have to have those types of units to rent for the affordable units as well. So I think they're looking for more equity, more comparable unit type in that regard. If you could go to the next slide. The next slide is for sale or mixed sale rentals. Sometimes you'll have a condominium building where the market condos are sold and the affordable condos are kind of pooled together and serve as affordable units. So again, it has to meet the same building standards, just like the rental, except for the interior finishes. Now they may be clustered by building type, but buildings must be dispersed. So you can have a cluster of them, but if there's more than one building of clustered units, depending on how large the property is, that cluster of units cannot be concentrated in one area. And the communities, with market single family or townhome units must provide the same for the low mod units. Now, there's some, I think, wiggle room or maybe need for clarification going forward here. It appears that this refers to if you have single family homes as your market product, and not necessarily have to provide single family homes for the, this is my interpretation again. This is something before you put pen to paper, you really need to speak with your attorney about. But you might be able to provide townhomes in lieu of the single family homes in that regard. And I also know that there's provisions for waivers. But that's something that if you're doing sale units, I think you really need to take a long, hard look at, and maybe even to wait for the next clarifying rules to come forward, because I think that that might provide some clarification, the new rules. Again, not all at less desirable locations. They need to be spread out. The square footage, again, this would be more like the 100% affordable rental. The square foot for each affordable sale unit has to be equal to or greater than the higher of the local code, the municipal code, or the balanced housing program. Again, you have to have access to all community amenities, and the same building type needs to be developed. If there's townhomes, have to equal townhomes, flats have to equal flats. So again, you can't take a townhome building, if you will, and take the footprint of a town. Again, this is my interpretation. Without some kind of authorization beyond the rules to take the footprint of a townhome and stack flats in that footprint, I think, again, probably needs a little bit of clarification. Bedroom window, again, required, as is adequate AC and heating. Okay, the next slide. So my comments regarding the building standards, and this is for a couple of different things. I think we need to take, sort of a bird's eye view at projects now. As administrative agents, a lot of times, we'll take a project and we feel as though that project is in a vacuum, that it has to meet a whole set of rules by itself. But in terms of building standards, it's not like I'm going to, as the AA, I'm not going to be able to know all of these building standards are being, abided by. There's no way that I could know that, whether or not it's, in the, something that was said in a planning board meeting or a planning resolution or what have you. So I think that these new building standards, before it was just the accessibility standard. Now we have all of these other requirements, site requirements, building requirements, etc. So I'm just pointing out here that I think that towns and the folks on the different levels need to work together to ensure that what is planned is actually implemented. And I named some on these slides: the construction officials, the planning boards, the planners, the architects, attorneys, the MHL, and the AA. Because, it's the one thing about these rules, I think that they are in many respects going to require more cooperation between different folks at the municipal level. The next slide, please. I'd like to get into the bedroom distribution now. Bedroom and income distribution. So some of the UHAC changes had to do, and these, they had to do with really implementing changes to the Fair Housing Act, amendments to the Fair Housing Act that have come over many years. Very low income households were never defined in UHAC. There's no such thing as a very low income unit, a very low income household, and they are now definitions in the Fair Housing Act. So the first thing that you'll see is that the definitions have been added to the UHAC regulations. They do require that the very low units, they require them for every rental property, but not every sale property. We should note that. And there is a requirement, although it's not precise, there's a requirement that does require the very low income units to be spread as proportionately as possible across the different range of numbers of bedrooms. So if you have, 30% 2-bedroom units, you would need to make sure that, as best as possible, 30% of the very low units are in the 2-bedroom category. The veterans preference. This was adopted in a long time ago now, 2013, I think. The veterans preference is part and parcel of the Fair Housing Act, but there's never been implementing rules until now, and they are being implemented for rental projects exclusively, I believe, because that's what's authorized in the statute. A new feature for bedroom and income distribution, and again, when we're talking about the bedroom unit mix, how many ones, how many twos, how many threes, the basics of what we do as administrative agents, how many, moderate, how many low income, how many very low of each level. A lot of what we have is still there. It's still set for, there's no major changes in the levels of affordability. You still have a 60% moderate income max for a rental unit and 50% for a low income max for a rental or a sale unit, and 30% max obviously for the very low unit. So those things still there, and you still have the weighted average maximum for a project. So you'll see the average cannot exceed 55% for a sale project, and the weighted average for all of the units in a rental project cannot exceed 52%. So all those things currently remain the same. What they did do is they added a few things, a few options that allow the AA, if you will, the town, if you will, the developer, to fix or fill in at least some of the gaps that were created because you have a lot of small projects, for instance, or because you have a rounding issue. So for our purposes here, and we'll get more specific in the future about this, I'm sure, but for our purposes here, we're going to say small developments can be treated in clusters, so that not for the sake of who the developer is or who the construction folks are or anything, but for the purpose of determining the low income, moderate income distribution, the number of bedrooms, et cetera, can be treated in a more clustered fashion, so that you can take a mix of 3 or 4 small projects together and do the compliance work that way. There's also options for all the projects now, for options for rounding up or down with certain limitations. You know the old thing, those of you who have been involved in this, if you're doing 1-bedroom units, you have to round down. When you're doing you have to round up. Sorry. And if you're doing 2-bedroom and 3-bedroom units, you have to round down in order to make sure that you're getting the right unit mix. Here, there's rounding options. So some of the units can be rounded up or down, and that's both in terms of setting the number of bedroom for each unit, and also the affordability level. So there's 2 roundings that can go on without getting into the nitty-gritty of the details. That will change 1 or 2 units in a project to make it a little bit easier to provide. When you have 5-unit project, 4 of them don't have to be low income technically, as they were in the old standard, so in the old UHAC. So now there's a little bit ability through both the clustering of the small developments and the rounding of all of the units. The only thing is that you have to make sure that at the end of the day, the town gets the credits that they're looking for. More on that in a second. So the other new features that the bedrooms must equal, and this is sort of a floor, the bedrooms must equal 2 times the number of low and moderate income units for non-age restricted properties. So at the end of the day, you have to have at least, if you have 100 units, you have to have at least 200 bedrooms. That's sort of a floor requirement. If you could go to the next slide. For age-restricted units, there's a couple of other features. The first is obviously you need 1 bedroom per unit overall. So that's the floor for, and that's pretty much the same as it is now. The pricing, though, interestingly enough, the pricing for 2 and 3 bedroom senior units, and by that I'm 55 or older, exclusively for 55 or older units, they've reduced the calculation for the pricing of those units. So in the past, if you had a 2-bedroom unit, whether it was a family unit or a um, age-restricted unit, a 2-bedroom unit would have to be based on a 3-person household, and to do the calculation, not having nothing to do with how many people are going to live there, just to do the calculation. Now that 2-bedroom goes from 3 persons to a 2-person household. So it reduces the price of a 2-bedroom unit in an age-restricted property. Also then, a 3-bedroom unit, which would be priced in a family or a non-age restricted property on the basis of a household of 4.5 persons, the 3-bedroom unit now would be priced on the basis of 3 persons. So again, lowered it. Now, as another sort of, not sure where it came from, rule, there's a well, I'm sure it came from folks who are looking for more space. So projects of 20 or more senior units, 20 or more age restricted units, have to provide, under this set of rules, 5% of the affordable units have to be at least 2 or 3 bedroom. So you need I don't think it has to be both. I think it can be or both, but 5% of the units have to add up to, have 2 and 3 bedroom units have to add up to 5% of any age restricted property with 20 or more units. Next slide, please. So the bedroom distribution, some comments. Again, I think the project level compliance now requires a higher level of review. So when the town decides on a plan, when the planners work on a plan, when the planning board is approving a property, when it's being constructed, all of those folks have to be part of this, because now is not only for the building specs, but now we're talking about the ability for you to provide a little bit of a different configuration in one property, but that is contingent upon a little bit of a different configuration on another property. So because of that, there has to be, the ability for a higher level review of properties as they come, when they start coming to the planning board, in order for those properties to, in a cumulative way, meet the goals of their fair share plan. Now, part of that problem too is, in a bad market, if things kind of grind to a halt and you did property A contingent on property B, providing the balance of units you need, you might not see property B right away if in a down building economy. So that's another thing to take into consideration. But because of the clustering of the small projects and because of the rounding options, I think it's really important that more people be involved and assure each other that what's being built in property A is contributing properly to the overall plan of the municipality. The team should ensure overall compliance to the housing plan, compliance to the ordinance, compliance to the planning and zoning approvals. Okay, and occupancy standards. So this is one of my bugaboos for many years. HUD had come out a long time ago now with guidance on real estate folks not becoming too involved in the relationship of family members with one another, meaning that you really need to assign people to units by people and not by who they are, what the relationship to one another is, or what gender they are, or all those kinds of things. And I know that that's been, part and parcel of the rules for many years, but it's really, and I would say in contradiction to like a lot of the HUD guidance. And one thing that we always tried to do in our company was to kind of stay out of everybody's business. I think that this is being accomplished by this new income distribution, the occupancy standards. Excuse me, silent. The ensure that the bedroom is occupied by at least one person. So except for age restricted units. So age restricted folks in those developments, and I guess that coincides with the 2-bedroom option, you do not have to abide by the at least one person per bedroom rule like you do for the other units. Provide 1 bedroom for every 2 adult occupants. Provide a bedroom for every occupant under the age of 18 unless the household requires a different arrangement. An arrangement may not result in more than 2 occupants under the age of 18 occupying any bedroom. So again, they want to max out at 2 people per bedroom, and the minimum for non-age restricted properties is 1 person per bedroom. Avoid placing 1-person household into a unit with more than 1 bedroom. I know that today there's a lot of folks who are looking for a place to sleep and then a place to work because they work out of their homes. And just as my own comment here, I think that it's very clear that that's not really what we're supposed to be about. And I think that that's a perfectly appropriate and well deserved changes, I think, to the regulations. Next slide. Thank you. So just a few words about the program equities, the fees, the amenities, and such. UHAC changes, and the one thing that's changed for rental properties is that unlike sale properties in the past, if you were doing a new development, technically speaking, there was no ability to increase the initial rent for units that were coming online in excess of a year after the first initial units were coming online. So when there's a long build out process, the landlords, if it was all in one approval, would be responsible for maintaining that same initial rent for all of the units, even though it's going to be a year or even sometimes 2 years down the road. What the new rules do allow for, under certain conditions, they allow a phased property to reset its initial rents for future phases, as long as those future phases are in excess of a year from the first phase. So that's, I think, really helpful to. It provides a lot of equity between the rental and the sale program and developers. Operating cost added to now this is a small change, but to me it means a lot. The words operating cost were added to the category of fees that are prohibited increases to LMI tenants. So over the years, I guess you see a lot of increases based on all kinds of things. And then it became a CO fee. If the town requires an inspection in between tenants, then each tenant will have to pay their own CO fee. Then there's a move out fee, there's a move in fee. And all of those things are specifically prohibited. So I think that there's a greater emphasis on being specific that you can't just charge fees, um, to layer on top of the net tenant rent to the landlord. And I appreciate it being clarified. Anything that can be clarified or specific is kind of helpful in this regard, especially. It does specifically say that the municipal housing liaison has authority for any additional charges. And that might be an error. I think it might be the administrative agent, but I will look that up. Specific fees include, as I mentioned, CO fees, move in, move out fees. Parking fees, which I don't believe this section is finalized yet, but parking fees under certain conditions are prohibited. Again, I think that we probably need to see the next version of UHAC to see how this comes out. And then pet fees are limited by a dollar amount. Currently, I think in the temporary ordinance, I'm sorry, the temporary UHAC that's been published, the amount of a pet fee is can be no more than $30 per month, and you cannot charge the pet fee, the initial pet fee. A lot of times there's sort of this initial fee of $200, $300, $500 or whatever, and then ongoing monthly pet fees. I think part of what the attempt here is to keep the increase limited to a percentage of the rent, if you will. And if you keep if you're adding increases to pet fees over years, that could almost outshine, the increases on the actual rent, because there was no maximum. I will say that the maximum increase in rent and the maximum increase in sale prices generally follow what there is today in the old UHAC, with a little bit of tweaks to the sale units, except to say that under the temporary rules that have been published and approved, the maximum rent to a sitting tenant in one given year was reduced from 9%, as it had been, down to 5%. So as an example, this past increase was 5.2% last year, 2024. In the future, that increase would have been, had it come up again, would have been just the 5%. So there is a limitation of the maximum rent on an annual basis. And again, that's to a sitting tenant of 5%, but it's based on the same consumer price index as before. I think that's it. So thank you very much, and I'm going to pass this back to Mark.
Frank, we got a couple of questions. Just kind of came in at the very close to the end, all related to fees. So there's Denise. Yeah, if you didn't see that coming, Denise has a question. She said, "Can fees for animals, key replacement be charged?" And I think we covered the animals.
Yeah, I think the key replacement is a fee. Anytime there's fees, late fee, an NSF fee, a key replacement fee, they're legitimate. They're based on doing extra work for the tenant.
Yeah, are those? I know we're stepping outside the affordable housing regs here, but those are lease provisions usually, right?
Right, and they're allowed under the regulations before and now.
Excellent. Is the pet fee, forgive my mispronunciation, is the pet fee per animal?
It doesn't say. So the
Yeah.
short answer is we don't know, but that should be something that we clarify or ask for clarification. I would assume it would be.
Yeah, I would assume so too, but it's not clarified. Or it's not clear in the emergency provisions. So last one is, can you charge a fee for any and all repairs to the unit?
Now that's a good question. Under the lease, a lease should include the repairs to the unit, and the only charges that should be passed on to the tenant is for abuse. So if somebody abuses something and you have to go in there and fix it, if you can show that it's because of the tenant's abuse of it, I think that that could be in the lease as a reimbursable expense. But you can't charge people for replacing filters or doing the kind of maintenance that's normally done at a property.
That's great. So Diane had a question. This might be a good one for Megan. I don't know, but can you still relocate your obligations to an offsite location?
That is not something that is really covered in UHAC. That's more going to be part of the round 4 plan. I say there's a movement to definitely on-site location. But
I think that is in the regulations
Okay.
in the legislation, I should say.
In the Fair Housing Act, yeah.
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 I think they've added that. I believe that without a good reason, they're looking at having it on site.
And Daniel had a question about the size of the market rate units. So did I hear correctly that affordable units have to be the same size as their market rate comparables in the same project?
Yes, and if there's different size market rate units, it says the most common size of market rate units.
And then lastly,
That would be for rentals in a rental building, specifically.
Okay. And then Elizabeth had a question. I'm not sure I fully understand it, but she says, it sounds like she's referring to something that you mentioned, but she said, does that exclude reasonable accommodations for pets? And if Frank, if you agree that that's not clear, maybe we could get Elizabeth to.
Well, I think if you
rephrase
have,
that.
I don't think you can charge for a
Service animal.
service animal.
Ah,
I think that's a federal or a state law that you can't.
Elizabeth, please let us know if that's what you're referring to, and we'll, if not, if not, give us a few more words and we'll attack that. All right, I'm gonna share my screen and talk about a couple other topics. Oops, give me a second here. All right, I've got just a couple topics to discuss. We are doing relatively good on time, but I'm going to try to be efficient because we have a special guest that I want to leave a little bit room for. There were significant changes to the way in which income is calculated for the income determination process. And let me just make sure I'm at the beginning of my slides here on this topic. Yeah, okay. So the first thing that we saw is that we now have a peek behind the curtain on how income limits are calculated, and I know this was previously a task that was in the original iteration of UHAC was previously done by this math of determining the income limits was done by the state of New Jersey, and then more recently when the COA was not active, the responsibility or the AHPNJ elbowed its way in to help solve that problem and has been doing it for a very long time. And I think I've spoken to some folks that that weren't around back when the state published them, and they sort of thought it was a prescribed role for AHPNJ to do those income limits. That is not the case. We're doing them as a stopgap measure, and luckily judges around the state were allowing those income limits to and those increases in sale prices and rents to promulgate. It's our understanding that going forward, while the math is in the document, it suggests, the suggestion is that we all have to do this math independently. It's our understanding from the state that they are going to publish the income limits, allowable increases, the updated spreadsheets for pricing, the calculators and of doing calculators for the pricing and values. There's just a very nuanced change between the way those calculations were done in the past. Just a little bit of a rounding difference between the rule changes. Another big change was that you'll see a large deletion throughout the text that talks about the specifics of determining income. And what we're shifting away from was a system that was largely based around federal income certification process, but had multiple deviations, multiple little nuanced deviations that required you to kind of really understand those changes. And in some cases, if you had a project where federal funds were involved, yet the project was achieving COA credits, you now have two separate income certifications that you may have to do to accommodate these little nuanced changes. HMFA has abandoned, I call it UHAC unique approach to income determination, and we are now shifted firmly over into the federal standard, which is based around the Section 8 program, more recently retermed the Housing Choice Voucher Program. So we have the big benefit there is that not only with the example that I mentioned where you might have to do 2 income certifications for a unit, but we also expand our training opportunities. So you could, as an administrative agent, you could learn a lot by going to one of the national training opportunities for determining income certifications, and then we also get consistency now between our a lot of consistency, not perfect consistency, but a lot of consistency between our federal housing programs and our affordable housing units. The big deviation is that the income limits will continue to vary slightly, and that has a lot to do with the fact that in New Jersey, we're breaking up the regions into these 3 county clusters and 4 county clusters. I think there's a 4 county cluster. And the federal government is using a different geographic mix to determine its income limits. So that's where the slight deviations appear. The other big benefit of following the federal process is not only do we get training opportunities available, but there's some really cool calculators online that can walk you through the process of determining income limits. The big caveat there, obviously, is that the income limit itself may change. So you may have to manually adjust the income limit that your applicant is being tested against when you're going through that calculator process, but the function of the calculator still remains the same and is still very worthwhile to try to use. And obviously there'll be much more content on this and training going forward. Another change in the calculation of income or income determination section is that the idea that UHAC now permits the use of income certifications from other administrative agents and other income-based benefit programs. On one hand, I think it is anytime we can lessen the burden of applicants, I think that's always worthwhile. So someone who may be on a housing choice voucher program and providing all of the income information to maintain access to that voucher can now theoretically take that approval and share it with an administrative agent to document their income eligibility for the unit. Now, of course, we're still in a situation where we've got varying income limits between voucher programs and our state affordable housing, and more specifically federal programs and the state affordable housing. So there's a little nuance there that certainly needs to be factored in. And the other issue that we run into is that right now there is not a standardized administrative agent income certification form. So for instance, if an administrative agent, their certification is simply a letter to the applicant that says, yeah, we've looked at your income, everything looks great, you're good to go. it may not include really important information for the next administrative agent to act on that. So without a household size, without without details about the income, the specific income, for instance, too. Like if that certification did not specifically say how much income, what the income, gross income was determined to be, the presence of that letter to another administrative agent really isn't that helpful, because you got to know which unit to put them in. You also for not only for rent and pricing, but also for the number of bedrooms. So we've got some gaps to fill in here, but there's definitely some progress on improving and the predictability and the income certification process. Let's see. There's also a section on enforcement that and some changes that we've seen there. These are, I think, very much welcomed among folks that I've talked to, and I think among our panelists. There's one of probably my least favorite things to do is to send a flyer to be posted in the lobby of mixed income developments that basically remind all of the market rate people how much less their neighbors are paying for their unit. I thought that was always a really difficult and awkward. And there's also a new mandate now, which I think in practice was going on, but we did not have a rule to lean on to compel a landlord to provide this information. We now have a rule that says that all leases and renewals need to be submitted to the administrative agent. And we're, like, as I said, we're really happy to see both of those rule changes. Another enforcement change that we saw, oh, I'm sorry, I jumped ahead a little bit. We're seeing there's a change in the regulations that allows a municipality to, I don't hesitate to quote it because it's, but to, for lack of a better term, to share their administrative agent with developers. There could be there's some details on cost limits and how that cost sharing is done that it could probably be improved. We're also seeing some changes that say that towns are required to have a website that includes, or a web page at least, that where operating manuals can be found, affirmative marketing plans can be found, and contact information is available for all the affordable housing projects that are subject to an affirmative marketing plan. I think it's a great best practice. It's something I'm a big fan of, having all this information out in the public space. So kudos for that change as well. We touched this one already. There's also a big section in enforcement. Again, this probably falls under the category of things that were already going on, but maybe they were going on organically, or maybe they're going on through just kind of best practice. We now have mandates from in the enforcement section that developers need to provide a long list of detailed information about the units, about the development team, about the development process. This will pay huge dividends as units are being planned, as pricing is being set, as marketing is being done, and I think it's going to be a really helpful rule change. Very, very happy to see that one as well. Lastly, we're seeing there's some rule changes in the enforcement section that formalize the responsibility of the municipal housing and liaison and administrative agent to ensure proper compliance of all units. And there's now a very severe penalty for landlords that intentionally delay occupancy of affordable housing units. We are going to keep, well, let's see if there's any questions. Well, I'm going to resist the temptation to read the questions. I'm going to move on. Maybe we could get someone to jump in with any that we want to deal with live. So before I move on, I just want to say a couple of, just mention something that keeps coming up pretty regularly, and it hasn't popped up in our Q&A yet, but it's probably on people's minds. We've gotten some emails since December from folks that are asking if the spring semester of classes under the Affordable Housing Professional Certification at Rutgers Center for Government Services, whether or not those classes in the spring semester will be fully retooled and up to date with the changes. And I feel like you could probably all guess that this is an incredibly difficult process given the emergency rules that we're working under right now and the promise of some further refined rules. All I can say is that you know, the instructors have all gotten together, including myself and Frank and Rick, with Rutgers, and we've sort of talked this through, and we're going to do our absolute best, but it may be difficult to, especially depending on when the revised rules are released, and then even when they're released, they could be refined even further through the comment process. So we're going to do our absolute best to keep them as current and accurate as possible, but it could prove a challenge. The other factor that I want to throw into this is that there's a set of regulations on the topic of training and requirements of administrative agents and municipal housing liaisons, and those are being drafted by our friends at DCA, specifically the Office of Local Planning Services, and we have Heather here today to talk a little bit about that. But I'd want to just sort of recognize for a moment that the local planning services have been incredibly busy working up round 4 numbers, retooling and updating their housing trust fund reporting website. I'm sure everyone's a huge fan of that website by now. They've been tasked with the responsibility of reviewing the training opportunities available to administrative agents and municipal housing liaisons. As I said, we're fortunate to have Heather with us today. She's a longtime AHPNJ member. She's a OG policy committee member, professional planner, and most recently she's joined local planning services, and she's here to give us a little bit of an update. Heather, if you'd like to take it away.
Thanks, Mark. Yeah, so what Mark said, and there you go. Good morning, everyone. Thanks for joining today. It's very important and still very new and uncertain information about UHAC. But I just wanted to give a little bit of a overview of what DCA is doing. As you know, we did do the numbers. The Division of Local Planning Services, where I am, is tasked with parts of A4 implementation. So we are working on that. 599, if you remember COA rules, 5:97 was, and 98 were the last ones that were knocked down. Now we're on 599. They will be coming out in the register March 17th. So those are going to deal with parts of A4 that we have control over, which to this group is going to be the things like it's the monitoring part of it, the reporting, and also the MHLs, AAs, certification, education, those kinds of things. So I wanted to just give a brief overview of where we are so that you kind of have a sense of where things are going. On the monitoring part, as many of you hopefully know, we had a February 15th deadline, and that will be an annual deadline going forward. That is in the legislation. So February 15th each year, your monitoring for the previous year will be due in the system. We did have a really great response, and I appreciate all the people who went out of their way, and I know worked for a long time, because there's a lot of information that needed to be put in. Some people continued to use the CTM system, the old COA tracking and monitoring system, and that was all revamped and moved into the AHMS system, not my acronym, but AHMS, which is Affordable Housing Monitoring System. And so there's past information that was put in. A lot of times what we see is that as of 2015, when COA was kind of out of the business, it lapsed, and now we're asking everyone to go back and put in all that missing information. So I know that's a lot. We're expecting this first year is going to be a little bit of a learning curve for everyone. We did get a great response. We did get a good, a lot of people did really good work. We've got a lot of trust funds that are reconciled. We will be reaching out to towns, I expect, in the next few weeks to try to reconcile, especially the small differences, so that we can start fresh going forward. And we've got a year of, here's where we know where we're starting, and everything reconciles each year. So I just, if you are, especially trust fund, not the project unit stuff, we are not going to be quality controlling that, but trust funds, we will be. As far as the certification of MHLs, AAs, and RCA administrators, that is part of the rules that are going to be coming out. As you might imagine, and as Mark alluded to, the classes, COA had started these classes with Rutgers and AHPNJ long time ago. And so we are happy to be working with Rutgers again to make the changes to the classes as quickly as possible. As Mark said, that a lot of that's going to depend on when these new rules come out, because we're not going to be doing interim changes when things are going to change again. So, but that will be a part of the certification process. We, as well as some other things, just documentation of experience and things like that we'll be requiring for certification. It is a learning curve. It is building the airplane as we fly it. So, we're going to be doing our best to get information out there as soon as we can on a lot of this stuff. And I think we're going to learn a lot, this summer as plans and the court does its thing as far as certifying or the DJ actions and all of those, actually getting plans through. So, I just wanted to say I'm available. You can always reach out to ahms@dca.nj.gov. That's me. And we'll help you through whatever issues you're having. I expect that we'll get more questions as our rules are released, and happy to discuss, any aspect of those that people have questions about. So that's it for me.
Thank you, Heather. That's really helpful. So we're at time. I think we tackled most, if not all, the questions either in chat or live. So I guess this is a point of wrapping up. I just want to say thank you to Lindsay Britt, who puts these classes together and is the glue that holds it all, keeps this thing flying, and makes it seem so easy for us. Thank you. Also want to thank the Brian Rappaport and the program committee for their assistance in pulling this off, and of course all the presenters for taking time out of their day to put these slides together and sit in annoying Zoom calls with me and in the preparation for all this. So thank you for all those folks. And lastly, I want to just say that there's a lot more to come. I think that's probably everybody's sort of picked up on that at this point, that there are we're expecting new rules, expecting them most imminently from both HMFA and, as Heather mentioned, from DCA. So there's a lot more to discuss about this. As information is made available to us, we will certainly be sharing it with membership through our mailing list. If you did not get notification of this event through email from AHPNJ, do yourself a favor, go sign up for the email list. It's towards the bottom of the homepage at ahpnj.org. And we look forward to the next time we see you all, and I hope everyone has a great day.
Thanks. There will be a short survey when the webinar ends, so everyone's feedback is always appreciated. Thanks, everybody. Have a good day.